All right. Let's see if we are in fact streaming, because this is always the thing. Are we? I don't know. It doesn't look like we are. It doesn't look like we are. Well. Hmm. 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 Just got back from Illinois. Oh, there I am. Lord have mercy. I am in fact streaming. All right. Well, I probably should stop playing my video while I'm doing this. Now that I have completely boomered it all up, and then what I can do is there's a thing I can do where can I move you? I'm going to move you over here so people can see my chat. Yeah, you guys can see that. That is freaking awesome. That is freaking awesome. All right. So, one of the ways that you can get me to make videos is if you start talking about a video in my Discord. And a bunch of people were talking about this video, apparently. I'm not a sports ball guy, and I don't do sports ball analogies. But one thing that has always struck me about Delete Laws is that he's like a wrestling coach, and he's just a bad wrestling coach. He's like the wrestling coach who doesn't have his own gym, and he travels around in a van, and he just wants to wrestle with little boys. But he says, all of the referees have it wrong. All the referees have it wrong. They don't understand that this specific move is legal, and it's legal because I think it's legal. Because when I read the rules, I see these rules as this move being legal, and so he wants to teach all the little boys that he wrestles with how to do this very specific illegal move. He thinks it's legal. He argues it's legal. He says it should be legal. He agrees with the other coaches and referees who think it should be legal. But at the end of the day, everybody he sends out to wrestle is going to get disqualified because they're going to use an illegal move. And it doesn't matter what Chili thinks is right or wrong. What matters is what the people who are actually going to judge what you do, what they think. It matters what the judges think. It matters how the judges understand the law. Not how Chili understands the law, but how the judges understand the law, because it's not going to be Chili who's going to end up judging it. It's going to be a judge. And so you probably want to understand the law the way judges understand the law. If you do that, it would most likely help you to avoid getting arrested in the first place. And if you do get arrested, it's beneficial to understand how judges are going to judge it so that you can not get convicted, so that you might be able to sue later and recover. All of these things are beneficial, but we are going to... Hi, yes, you're here and you want attention. All right, sorry, I have a attention-seeking dog. All right, so we're gonna start watching this. We are going to speed it up because, well, I don't know how long I'm going to do this. We'll do 1.5 just for now. We'll see if that works, and if we have to, we will. Oops. Yes.
There's no other way to say it. So if you want to be an activist or you are an auditor, I think I saw News Now Ninja in here a few minutes ago. So News Now Ninja, if you drop a comment, I'll put it up here on the screen. I was just getting set up before. And I'm talking directly to activists and auditors. And this is some of the most important stuff that I'm going to teach right now.
It always concerns me when people who don't have who can't show a basis for understanding a subject want to teach it. Like I fiddly fuck around in a fish room all the time, but I don't teach how to keep a fish tank because honestly, I'm still trying to figure most of this stuff out. I've been keeping fish most of my life since I've been in high school, but I don't know all the answers. I have this one illness on a bleeding heart tetra. Don't know what it is. I've treated it with Pemafix and Melafix. I treated it with that for like 2 weeks, 3 weeks, 3 weeks. I treated it with erythromycin for the full range of dosage. I don't remember how long that was. Was that like 5 days or something like that? That didn't do it. I treated it with a fungus cure. I forget which one. That didn't do it. I treated it with Riddick because it looks like it might be like a slime coat, like something might be under the slime foot. It's not ick, but somebody recommended I try that. So I treated it for like 5 days with Riddick, and I'm almost done with a week long of Prosapro, and it's still there. So like I don't understand enough about fish keeping to educate people on how to keep fish. I'll leave that for people like Corey from Aquarium Co-op or some of these other guys who have more actual knowledge than I do. But if you don't have a basis for it, like if you can't prove a basis for it, like if you can't show your skill in the courtroom, and Chili has never been able to show his skill in the courtroom, and he also doesn't have any credentials to his name, where other people who are learned in the law, like professors, like law school professors, none of them have given him a certificate or a degree or anything like that. He has no basis for fix top chat. All right, all chat, is that what you want? Is that better? Sorry, mea culpa. So he has no basis for claiming that he has the ability, the knowledge, the skill to teach.
When you go to film cops, you absolutely have to start your audit by saying, I'm filming the cops because I'm protesting the police. I don't agree with the
Again, magic words. Magic words don't work.
Police system. I'm protesting police using hell, which is the name of my camera. I think I'm going to put hell on there, but I don't want to promote hell. But I let them know that hell's coming with me. Hell is coming with me. So it's the most...
I mean, the only threat that Chili can make is I'm going to sue you, and it's going to cost you a lot of money to defend yourself against my suit. That's literally only... watching, I had to watch the first 16 or so minutes to get to this point to figure out where it was, because no one was kind enough to actually put a link into my Discord with a timestamp on it of where he started making these ridiculous legal claims. But his only real threat is, I'm going to sue you, and it's going to cost you at least $5,000 to defend against my lawsuit, i.e., it's going to cost you money no matter what. And I mean, that's just a fundamental misunderstanding on Chili's part. Most of these cops have either the city or the county will pick up their defense if it's warranted. Like, for example, in Las Vegas, his exchange of messages, Floyd Wallace's exchange of messages with the attorney from Marquis Arbaugh. Wallace was asking if that attorney was going to be representing the cops, and the attorney was like, "Hey, I have to wait for a determination from the city as to whether or not they are going to have a defender provided for them." And apparently, the city came back and said, "Yes, these cops are entitled to a defender at the city's expense." So it doesn't cost the city, or it doesn't cost the cops a dime. So I mean, it's his understanding of even something as basic as to who is going to foot the bill for these things is flawed. And other things, like he was on a college campus, and he was saying that he was on a college campus in a library at a college campus, and he was thinking that since it was paid for with public money, it's a traditional public forum, and colleges have always been limited public forums. They can control who enters the property and what's said on it. So, I mean, it's just, and another thing, like he thought that cops couldn't close a sidewalk. Like, yeah, cops can close a sidewalk. But like the city, the state, they can close the sidewalk. for repairs, to do other things on it. I mean, they can do that. They can close entire roads. Like, why does he think that the cops can't close the sidewalk if they can close down an entire street? It just, none of it makes sense. He's so ridiculous and over the top.
Most important thing, and I'm going to show you the reason why. I know on a lot of the educational stuff, people tend to tune out, but the reason why I say I'm a constitutional law scholar is you guys are about to find out. I'm going to lay out the Constitution and the Bill of Rights in ways that you never knew before.
In ways that judges never knew before and justices never knew before. I mean, ways that nobody who actually matters knew before or accepts. I mean, that too. So he's going to lay out the Constitution and all this other stuff in a way that is completely unfounded and unaccepted.
The stuff I'm going to teach you today, the stuff I'm going to teach you over the next several weeks, you did not learn in school, you did not learn in high school, you did not learn in college. The real unedited version.
You didn't learn it in law school either, because it's not the right way to teach things.
Of history is what I'm going to teach. The foundation of law, the actual building blocks of how the 13 colonies going all the way up from 1607, go back to Roanoke colony in 1585, and then go all.
He gets lost in the history of things, and the history of things isn't important. What is important is the current state of the law today. What does the law mean now? That's it. That's all that's important.
All the way up to 1681 with the founding of Pennsylvania by William Penn, and then in 1688.
See, again, he did this with that fucking that chart that he picked like various things to put blurbs up over. Like he picks random tidbits, random factoids, completely meaningless in and of themselves. But I think because he knows these little trivia questions that somehow makes him. It gives the indicia that he actually has an in-depth knowledge of the subject, I guess.
William Penn is going to write the. You want to look that up? You can look it up. I'll type in the comment section. Frame of Government by William Penn. So I put it in the comment section for you guys. This is what I'll be teaching.
Who the fuck cares what William Penn wrote? I'm sorry. Who the fuck cares what William Penn wrote?
In the first week of Constitutional Law Scholar. Well, we're going to go all the way back to the palpable by. So the Columbian. I'm not going to bore you guys because you need to see the graphics. You need to see the visual.
How much Adderall has this motherfucker taken? Because he is all over the goddamn place.
But if you are an auditor and you film police, this next portion of what you're about to hear and what I'm about to teach you is imperative that you learn it. And so every single activist or auditor, any single person who ever goes out and they want to take on the police with their camera to shine the light of transparency, you start off every single time where you say, I'm protesting police and that's why I'm filming them. You have to say.
You don't have to say that. It's completely meaningless. It is hearsay, 100%.
Say those exact words, and I'll show you exactly the reason why. It is imperative that you use the proper wording if you're an activist, because if you
see, he goes back to the sovereign citizen magic words. If you say the magic words in exactly the right way, then you'll win. And the law isn't about saying the magic words in the right way.
Use the proper wording. These dumb pigs are going to arrest you, and you got them. You got them. You absolutely got them. So I'm going to open this up and we're going to listen to this. And if learning something's going to bore you, then let it bore you. Because after this, we're going to go into the police brutality thread that I've been saving up for the last 4 or 5 days. There's so much tyranny in our country. We're watching these jackboot thug pigs just ruin people left and right, arrest them without probable cause. We're going to talk about the case Murphy versus Schmidt. And so, you won't need to.
Murphy versus
You won't need
Schmidt.
to. You don't really need to. I'm going to stay on camera with you guys because I want you guys to really follow this. I want you guys to really follow this.
I'm going to stay on camera with you because I want you to follow this. How does that even make sense? Really? You got to come over here? Really? Really? Well, you're going to get a chicken. You're going to get a chicken, kids.
This is some critical stuff here, especially for guys like News Now Ninja. This is some critical stuff. We're only going to listen to the first 5 or 10 minutes of this, and then we're going to jump into some police brutality videos. But I want you guys to learn this. Everybody hit the like button, if you would, please. Hit the like button. And the sound is okay. Cool. News Now Ninja. Okay, so we're going to go Murphy arguments. And Ninja, you are going to love this. This is a total...
Murphy, Schmitt. Murphy versus Schmidt. Download. Oh, you guys probably can't see. Go download. All right, we have Murphy versus Schmidt.
total game changer for News Now Ninja. An absolute game changer. So let's do this. Let's jump right into this. And this lawyer who's going to put the argument together for Murphy, he's going to lose the...
Wait, there was a... Murphy versus Schmidt, oral arguments. Oh, that's his own video? Oh, boy.
Let's do this. Let's jump right into this. And this lawyer who's going to put the argument together for Murphy, he's going to lose the case, by the way. His arguments are spot on, but the judges in our country, they don't care about the Bill of Rights. They don't care about...
His arguments are spot on, but the judges don't care about the Bill of Rights. Well, first of all, these are justices, not judges. You might want to take that little factoid into consideration. And maybe they do care about the Bill of Rights. Maybe they don't interpret these things the same way you do. Maybe. Because you came to a weird ass understanding of Neves versus Bartlett, and so you're probably going to have a funk ass understanding of this as well. Oh shit, I was supposed to say at here I'm alive. Yeah. Thanks, AD Liz. Thank you. I appreciate you. Miss Almost Anal.
Our Constitution. This is not a constitutional state. This is a state of tyranny, as you know. This is a prison state, police state, death state. That's what this is, and we're living through it. So if you're an activist,
it's a death state, folks. I mean, I don't know about that. It seems like there's a whole lot of living people for a death state. Stupid question, but why don't the police, post offices, or wherever just play copyrighted music when the 1A people come around? I've seen some cops do that. I don't know. You might be able to craft a lawsuit that they are infringing on your right to film by doing that. Because they are acting in their function as they're representing the state in that. I know city police, whatever, but by the state I mean they're representing the government, and they're doing it specifically to chill your ability to record. So I mean, I think there might be an argument that you could make.
Or you want to film police, you got to listen to this.
So he's going to play the argument that the losing attorney made. And, wouldn't it be more productive to go over the actual, the decision where they lay out specifically what's going on? We're going to go over it, I guess, because I don't know. I want to read it. I want to see what he's talking about so that I have a basic understanding. Officer Michael Schmidt stopped Mason Murphy while Murphy was walking on the wrong side of a rural road. Murphy refused to identify himself, and the two men argued for a few minutes before Schmidt arrested Murphy. Murphy sued Schmidt for First Amendment retaliation. The district court granted Schmidt's motion to dismiss based on qualified immunity. We affirm. Schmidt was patrolling a rural road when he saw Murphy walking along the right side of the road with traffic. A Missouri statute requires pedestrians to walk only on the left side of the roadway or its shoulder facing traffic, which may approach from the opposite direction. Schmidt stopped his car, approached Murphy, and asked Murphy to identify himself. How many pages is this? 9 pages. Okay. Murphy refused to identify himself, and Schmidt put Murphy in handcuffs after 9 minutes of argument. Murphy asked why Schmidt arrested him, and Schmidt refused to answer. On the drive to the sheriff's department, Murphy again asked Schmidt why he was being arrested. Schmidt responded the arrest was for failure to identify. Once at the station, Schmidt can be heard making a call to an unknown individual and saying he saw the dipshit walking down the highway and he would not identify himself. Schmidt then asked the unknown individual, "What can I charge him with?" Officers eventually identified Murphy by a credit card he was carrying. Officers confirmed Murphy had no outstanding warrants and released him. Murphy was in the jail cell for approximately 2 hours. Murphy asserts he was arrested in retaliation for exercising his First Amendment right to argue with the police. Murphy filed a suit alleging unlawful detention and First Amendment retaliation. The district court granted Schmidt's motion to dismiss based on qualified immunity. The parties agree Schmidt had probable cause to stop Murphy because Murphy was in violation of Missouri Revised Statute, Section 300.405. Murphy appeals to the dismissal of the First Amendment retaliation claim. We granted a review. To survive a motion to dismiss, a plaintiff must state a claim for relief that's plausible on its face. The First Amendment retaliation claim has three elements. 1, the plaintiff engaged in protected activity. 2, the government official took adverse action and the plaintiff against the plaintiff that would chill a person of ordinary firmness from continuing in the activity. And 3, the adverse action was motivated, at least in part, by the exercise of the protected activity. In First Amendment retaliation cases, probable cause should generally defeat a retaliatory arrest claim. That's Neves versus Bartlett. We talked about that yesterday. The Supreme Court arguably reserved one narrow qualification to the general rule. And they arguably reserved it because they didn't make the decision based on it. So technically it's dicta, but it's pretty strong dicta. And so, I know the Ninth Circuit has run with it. I showed you a case yesterday where the Ninth Circuit ran with Neves versus Bartlett. They ran with that dicta. So it's pretty strong dicta. And the Eighth Circuit, this is Eighth Circuit, right? I did see Eighth Circuit. Yeah, this is Eighth Circuit. So the Eighth Circuit is saying that it's arguable, but they're going to run with it too. So the Supreme Court arguably reserved one narrow qualification of the general rule. The no probable cause requirement should not apply when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been discussing but not applying such exceptions. See, that's what makes it dicta. Evidence as to the exception allows, quote, an objective inquiry that avoids the significant problems that would arise from reviewing police conduct under a purely subjective standard. Because this inquiry is objective, the statements and motivations of the particular arresting officer are irrelevant at this stage. Again, that is directly from Neves versus Bartlett. So it doesn't matter what the officer's intent was, they look at it objectively. The parties agree Schmidt had probable cause to arrest Murphy because Murphy was in violation of Missouri Revised Statute Section 300.405. Murphy argues the facts in this case fit into the possible Neves exception because, like the hypothetical in Neves, this is a situation where, quote, officers have probable cause to make arrests, but typically exercise their discretion not to do so. But here, Murphy has not pleaded facts sufficient to demonstrate a, quote, facial plausibility, end quote, that police commonly see violations of Section 405 or 300.405 on similar roads and fail to make arrests. That's the problem that auditors are going to run into. The hard part is to plead the specific facts. It's easy to say the police generally don't make arrests for this kind of thing, but that's not sufficient. You have to actually plead facts. Supreme Court in Neves. Okay, we're almost done. I guess this only goes a dissenting opinion. Okay, good. All right. The Supreme Court in Neves gave an example of an individual who was arrested for jaywalking in an intersection where jaywalking is endemic but rarely results in arrest, while the individual is vocally complaining about police conduct. Murphy relies heavily on the similarities between jaywalking and walking on the wrong side of the road to prove his point. While the crimes of jaywalking and walking on the wrong side of the road are similar, the totality of the circumstances between the example given in Neves and the facts of this case differ. The hypothetical given by the Supreme Court specifies an arrest for jaywalking at an intersection where jaywalking is endemic. That means it happens all the time. Murphy's assertion that, quote, a reasonable opportunity for further investigation or discovery will show that no one else in recent memory has been detained or arrested by any law enforcement officers for walking on the wrong side of the road, end quote, does a little to show officers typically witness violations of Section 300.405 and exercise their discretion not to arrest. So just saying that arrests aren't common isn't enough. They have to show that officers are aware of those misdemeanors or infractions or whatever those are and choose not to arrest. Murphy also asserts that, quote, walking on the wrong side of the road occurs all the time on the highways with wide shoulders, and the situation was one, quote, where officers have probable cause to make arrests, but typically exercise their discretion not to do so, end quote. These are, quote, threadbare recitals of a cause of actions, elements supported by mere conclusory statements that are not entitled to the assumption of the truth. Iqbal. Alpha Fox Adams says, shit, couldn't overcome Twickball? Yeah, it's hard. Have you seen any of Chili's pleadings that have managed to meet the pleading standards in Twickball? I haven't. To determine whether a complaint states a plausible claim, we draw on experience and common sense. As a matter of experience and common sense, the present allegations do not show violations of Section 300.405 are so common as to be, quote, endemic, end quote, or are so frequently observed as to give rise to a reasonable inference that officers typically exercise their discretion not to arrest. The above notwithstanding, Murphy argues the subjective intent of Officer Schmidt is so apparent as to require a finding of retaliation. We disagree. The Supreme Court has been clear that a particular officer's state of mind is simply irrelevant, and it provides no basis for invalidating an arrest. Such a position is necessary as protected speech is often a legitimate consideration when deciding whether to make an arrest. To ensure that officers may go about their work without undue apprehension of being sued, we generally review their conduct under objective standards of reasonableness. That comports with my understanding that I spoke of yesterday about the application of Neves. So, all right, let's see where my understanding, where the Eighth Circuit Court of Appeals understanding went wrong.
With traffic. May it please the court. I represent Mason Murphy. This is a case here.
He didn't know who he was. He saw some
Civil rights case. My client was peacefully walking on a rural...
Shoot, I'm so sorry. I absolutely need headphones for this to work. I'm so sorry. I apologize. I will need headphones to make this video. After I plugged this bad chicken in. Okay. We are back on now.
Nice crotch shot,
Forgive me for that. I apologize. I had to do some stuff, and there's some stuff in here that I can't show you.
Oh, nice crotch shot. Oh, my fucking God.
Guys, just yet, but I will be showing you everything in this studio very, very soon. This what I'm going to teach you right now, though, is really, really good. This is really good stuff.
Road. May it please the court. I represent Mason Murphy. This is a case here on a motion to dismiss granted by the district court. It is a civil rights case. My client was peacefully walking on a rural road. He was on the wrong side of the road. We acknowledge that. There's a Missouri statute, 300-405, says you have to walk against traffic. He was walking with traffic. And Officer Schmidt rolled up on him and said, "Give me your name." And my client said, "No." A quite elaborate argument ensued, went on for 9 minutes. Finally, my client was placed under arrest. And he sues now for retaliation.
Okay.
All right. Well, I guess I actually read the case to you, so maybe he's just doing the same thing. He's just allowing the attorney to argue it instead.
Okay, now, I don't know if Mason Murphy is white or black, but what I do know is Missouri statute 300.405 is a racist law created in Missouri to arrest black people. And let me show you exactly what I'm talking about. So if you take a look at the statute, the Missouri statute.
Let's take a look at the statute, I guess. Take a look at the statute. Yep. All right. Is this the official one? Missouri.gov. Okay, yeah, I guess this must be the official one. All right. So we have 300.405 pedestrians walking along roadways. 1. Where sidewalks are provided, it shall be unlawful for any pedestrian to walk along and upon an adjacent roadway. 2. Where sidewalks are not provided, any pedestrian walking along and upon a highway shall, when practicable, walk only on the left side of the roadway or its shoulder facing traffic, which may approach from the opposite direction. Okay. This is racist? All right.
Statute is going to be created August 28th of 1965. Pedestrians walking along the roadway. So, I can't take you down all the research that I did on this, but what I can tell you is that in August of 1865, the Civil Rights Act of 1964 passed, and for the first time, blacks were allowed to walk into town.
All right. Let's see when this passed. It passed in 1964. Okay. Passed in 1964. 1965. Where did you see that? Where did you see that? Oh, here we go. Well, I don't know. So I'm not going to spend too much time searching this. It was passed in August of 1965. It was passed a year after the Civil Rights Act of 1964. I'm not sure entirely why he is connecting the two. I don't see anything in here that looks racist. I'm not. I mean, this is. I don't know. I guess we'll have to see his functioning theory. But like, is he suggesting that black people walk on the sides of a highway more than white people? I don't know. Or black people are incapable of following the law? Like, why is this law racist?
Town. Remember, the 1950 Model T Ford, that was when everybody who was white got a car, but very few black people had cars. Very few black people had.
So, car ownership in 1964, black people didn't own cars. Okay, all right.
And so most people walk down the road. So Missouri, which is one of the most racist states in our country, if you're from Missouri, I'm really sorry.
Missouri is one of the most racist states in our country. Okay, like, all right.
Your legislature and your government has been racist, and we're going to go over that in detail in Constitutional Law Scholar. But let me ask you a question. Why would you create a criminal code in August 28th of 1965? Why would you make that a criminal act? Don't get me wrong. I'm not saying that.
What? They pass laws all the time. Was there a previous version? Oops. I don't know if I really want to. The Voting Rights Act of 1965. Okay. Missouri governor term limits. Session laws. Siobhan's desperately trying to get Kenzie to play. All right. We want to do 300.405. Let's see if we can search that. Do. It went to here. It went to here. I don't know. I don't see 300.405 here. What else do they call this? Let's try pedestrians walking on roadways. 0 results found. Browse. I mean, couldn't they have just like, I don't know, digitized them all like word searchable? Couldn't they have done just to digitize them all word searchable? Wouldn't that be great? But look at all these laws they pass. I mean, it seems like every couple of years they pass a whole new batch of laws. This is just in the 1800s. Now we're in the 1900s. Look, they're passing more laws. They pass laws pretty often. We're on page Okay, hold on. And maybe we'll just go to the next page. Looking out my back door. Convened on January and adjourned July. And this was, I don't know, page 445, section 88. All right, let's go. Page 445. Okay, so it's not this one. I need page 445. That was 65. I need page 445. Looking out my back door. Look at all these laws they're passing. Boy, they must have really been responding to my racisms. We're getting there one page at a time, kids. One page at a time. And it was 445, right? We're in the motor vehicle section. Oh, look at all these things that they're doing. Oops, page 445. Motor vehicles, model traffic ordinance. An act regulating vehicular and other traffic in cities and providing for its adoption in cities. Look at all my racisms here. Look at all my racisms. So in 1965, apparently they adopted a whole new set of traffic ordinances. Where is this at? 1965, 445, section 88. It's 445. I don't know. Section 88. Pedestrians walking along roadways. This is under a section called Pedestrians' Rights and Duties. So is pedestrian subject to traffic control devices? Is that also racist? I don't know. Pedestrians right of way and crosswalks. That must be racist, right? Because if pedestrians have, well, hold on, let's work this out. So Chile logic. In 1965, white people owned cars at a higher rate than black people did. So black people were walking more, and pedestrians had a right of way and crosswalk. So black people had priority over white people in 1965 in Missouri, and so in 1965. This pedestrians' rights and duties, pedestrians' right of way, and crosswalks is racist against white people. Right? Right? I mean, this is fucking stupid. But anyway, we'll go back onto this fucking moron.
You can't walk with traffic behind you. You have to walk with traffic coming towards you. So who created that? The racist legislator. Because I'll tell you why. 1954, Brown versus Board of Education passes and it desegregates America. Before 1954, if you were black, you were not allowed to walk into town.
Why are we? So this law was passed in 1965 as part of a apparently revamp of the motor vehicle codes. Traffic Violations Bureau, stopping, standing, or parking, prohibited in specified places. I mean, I don't know. It doesn't seem like this is at all related to something that happened in 1954, but I guess this is a post hoc ergo propter hoc argument.
Town, especially after dark. If you're in town after 5 or 6 p.m., you're going to get beat or you're going to get lynched. Lynchings happened all the way up until 1960. I'm going by NAA statistics. It's going to be 1965, 1966.
Okay. What? We're comparing a law that requires you to walk towards oncoming traffic to lynchings now.
Those civil rights workers were lynched. And so Missouri created a racist statute in 1965, August 28th, you're looking at it right there, that said that it was a criminal act for you to walk the wrong way down the road. This is a racist law.
I mean, can like, is this just Chile making random ass assertions? Like, can you show something like where this disproportionately affects black people or something? Can you show something? Something?
I don't know if anybody can find the video.
Alpha Fox Adam says, and white people weren't lynched. Weird. The funny thing is on Chile's that wall thing he did where he shows lynchings, he has white lynchings graphed next to black lynchings, and white lynchings are way more than black lynchings. which, I mean, I don't know.
If anybody can find the video for Mason Murphy being arrested, it's a 9-minute long video. Apparently, there's pretty far back and forth. I would like to hear that. And I don't know if Mason Murphy is black or white, but I can tell you this. Missouri Statute 300.405, it was created to be able to arrest black people who walked on the wrong side of the road in Missouri in 1965.
It looks like it was created to be able to arrest any person who's walking on the wrong side of the road.
And that's exactly what happened. Like I said, if there is a law on the books, there is a cop ready to enforce it. So
weird that there's a law on the books, there's a cop ready to enforce it. Well, first of all, there are what are called something like Blue Sunday laws or something like that. I forget the exact name of them. But there are laws that are still on the books that are unenforceable and unenforced. But I mean, imagine how stupid you have to be to think it is somehow a revelation that cops are willing to enforce laws. I mean, it's almost like it's their job. It's almost like it's their job to enforce the laws. It's almost like if they weren't enforcing the laws, they wouldn't be doing their jobs. Fucking crazy.
What do I always say to you guys? We are living under a set of racist laws created for black people. We're creating this law. Don't worry about it. It's only going to be applied to blacks. And so...
Wait, so he doesn't know if this Murphy guy is black or white. What is this guy's name? Mason Murphy. That sounds like a black guy. Let's see. Mason Murphy, Missouri. Do you have a picture of Mason Murphy? I don't know. Oh, hold on a second. Mansu's. I am using an ad blocker, you bastards. Can you give me a picture? Thank you. You gonna give me a picture? You gonna be at all useful? No. Useful? No. Useful? No. No, not useful. Well, so just a stupid thought, but I'm just wondering, like, if Mason Murphy's attorney could have made anything resembling a plausible argument that this was based on racisms, I'm relatively certain that the attorney would have made that argument. But I guess Chili's just smarter than Mason Murphy's actual attorney.
Oh, Mason Murphy, if he's black, then he's still experiencing the racism of 1965 Missouri legislators who passed a law that said it's illegal for you to walk on the left side. Now, I understand if there's a...
So the subjective intent of the lawmakers in 1965, 28 years ago? No, 38 years ago? No, 68 years ago. Math is hard. So the subjective intent of legislators 68 years ago somehow changes this law that is neutral on its face into being racist. Here's a dumb question. Here's a really stupid question. Michael Schmidt. What race is Michael Schmidt? What if Mason Murphy was white and Michael Schmidt was black? What about Jerry Pedigo? That sounds like a very white person. What if all three of these judges are black? What if Michael Schmidt was black? And what if Mason Murphy was white? Since we're playing the what if game. What if? 58 years, math is hard. Hold on. 60 and 60 is 20. So 28 years. Yes, you're right. Or 58 years. Yeah, you're right. Sorry, my bad. Math is hard. Shush. I'm a lawyer, not a math scientist. Well, rock child of the 60s, you don't look a day older than 29. All right. Enough of my poor mathing.
I understand if there's an outcry, if there's a
bullshit, Yuri. You're Yuri. You're Yuri. You're not Jerry. You're Yuri.
If there's an educational forum where you walk on the road and there's signs up that say you can't walk on this side of the road, you have to walk on this. I understand that in the idea of public safety, but they didn't create statute 300.405 based on public safety. They created it after 1964 Civil Rights Act. And then what happened was when black people were walking in.
Again, this entire argument is post hoc ergo propter hoc. It's okay if you put a sign up, but apparently, according to Chile, apparently black people are not smart enough to just be able to follow the rules of the road. They need to have signs in their faces all the time or something. I don't know.
Into town, they created a way to arrest those black people in Missouri. I don't love this. I'm pretty basic for being Colombian. I have green eyes. Most cops see me as a pure white guy until they arrest me. My name is Jose Maria.
You're white, Chile. You're white. I don't care what country you came from, bro. You're white.
So it's a crime to walk down the wrong side of the road. So the cops see Mason Murphy walking down the road. I don't have that video. If anybody wants to find that video, I'll share it on here. But we're living under the racist legislation.
What if it does turn out that Mason Murphy was black and Schmidt the cop was white? No. What if Mason Murphy was white and Schmidt the cop was black? Wouldn't that be fucking hilarious? I would laugh my ass off. Watch Chile try to turn it into more racism still.
Legislatures of Missouri, and this goes up to federal court, and the judges in the federal court say no, it's perfectly fine to arrest him, even with no probable cause. I'll let you listen to the rest of this, and then
No one says it's okay to arrest without probable cause. I mean, unless I'm misunderstanding this. I thought they agreed. I thought both sides agreed he had probable cause. The parties agree Schmidt had probable cause. The only Chile in this entire equation between the justices, the judge, the attorneys, only Chile thinks that there was no probable cause. Literally everyone else thinks there was.
And we're going to stop and talk about this a few times as we go.
For exercise of his First Amendment rights, finally,
So they pull him over on the side of the road, and then an argument ensues for 9 minutes. I don't have that video. Maybe someone has that video. Maybe it's somewhere. But no.
was placed under arrest.
They pull him over. They pull over a pedestrian.
And he sues now for retaliation for exercise of his First Amendment rights. The first three elements of that are well established. The first element is a protected action by the plaintiff, in this case, exercising his speech to say, I won't say my name. Adverse action, that's an easy one, the arrest. Three is a little more complicated, motivation, retaliatory.
Thank God Tom Trujillo put all the little accent marks over the E and the I, just to make sure that you knew that Jose Maria de Castro is not white. Except he's white.
Animus of but-for test, but I'm sure get into that in more detail later.
Now, if you're an activist or you film police, you definitely.
So Miss Zimbabwe was just announced or crowned or whatever they do, and it's a white gal, pure white. And the argument that Chile's making, because he's like his family's from Colombia, would be the same thing as that white gal or Elon Musk arguing that since he's from South Africa, he's black because he's from South Africa. You know what I mean? It's a fucking stupid argument.
I definitely want to listen to this next part.
And the last element really is where this case lives and breathes. That is the requirement, normally, most cases.
Logan says every pole dancer is doing for tuition. You know what? Don't you want to support their college fund? Don't you want to allow them to better themselves? Slip a few dollars in their bikinis.
That there was no probable cause for the arrest. So here we go to Atwater, which says that if a officer has any reason to arrest a subject, in other words, the subject has broken some law, that the subject can be arrested and there's no retaliation.
Okay, so this is going to switch right here. News Now Ninja and every other activist, anybody who ever films police, you gotta listen to this. But let me just cover real quick Atwater versus City of Lago Vista. 2001 case. So just so you know, the Rehnquist court that went until 2005, and then the John Roberts court started in 2005 when they switched chief justices out, and John Roberts.
Oh my Jesus Christ! Like the background trivia is fucking mind numbing.
Became the head of the Supreme Court. The only Supreme Court justice who was a Supreme Court justice longer than our current Chief Justice John Roberts was John Marshall, who was the third Supreme Court Chief Justice.
No one fucking cares, Chile. No one fucking cares. Get to the law.
It went John Jay, Ellsworth, and then John Marshall. John Marshall was Supreme Court justice for...
No one fucking cares, Chile. Get to the law.
Was it 27 years or something like that? 33 years? The point is, though, we have a tyrannical Supreme Court that doesn't have any sort of ethics obligations at all to us. And the only reason that any of us are happy with the current Supreme Court is because they're upholding our gun rights. Other than that, they don't work for us. They work for big corporations.
Now we come to the Neves case, which was decided in 2019. These events occurred in 2021 afterward. One of the things about some of the cases are that they're...
So I'm going to go back here real quick because these two pieces go together. You have to hear this. Atwater says that you can be arrested for any infraction of the law. That's what the lawyer just said to the judges. That's true. However, in 2019, Judge Neil Gorsuch is going to put a caveat in that if you are actively protesting the police.
That is not... the Neves court does not say that there is an exception if you're protesting the police. They do not say that. Absolutely 100% do not say that somehow you can't get arrested for infractions if you're protesting the police. They do not say that. That is an absolute fabrication, 100% a lie.
So here we go to Atwater, which says that if a officer has any reason to arrest a subject, in other words, the subject has broken some law, that the subject can be arrested and there's no retaliation. Now we come to the Neves case, which was decided.
Alpha Fox Adam says, my Argentinian grandfather was very German as well. Jawohl. Did he also like German shepherds? Was he a vegetarian? Did he have a wife named Ava?
In 2019, these events occurred in 2021 afterward.
He just said anything is arrestable. Atwater versus City of Lago Vista, 2001 says anything's arrestable. And then he said, well, let's go to the Nevins case.
One of the things about some of the cases are that there's a lot of crazy raucous behavior. And the Neves case is certainly a good example of that. We were at the...
So let's see if this attorney comes to the same conclusion that Chili does, that failed artist, says Alpha Fox Adam. Let's see if the attorney comes to the same conclusion as Chili does, that if you're protesting the police, you can't get arrested for infractions or other minor crimes.
Arctic Man Festival in Alaska, and there are lots of people crazy and drunk, and an officer comes up to one group and says, hey, your keg of beer is accessible to juveniles, you have to remove that. And then Mr. Neves approaches and says, hey, don't listen to those cops, they're a bunch of schmucks and things like that. And then the critical thing that happens is that they scuffle a little bit. And Mr. Neves is arrested, he sues and says, oh, retaliation because I challenged the police. And the court said, no, there's probable cause because you scuffled with the officer.
Did you hear that? If you're an activist and the cops are going to arrest you and you scuffle with them, which, as you know, I've spent 25 years on the wrestling mat, so you can't scuffle with...
I spent 25 years on a wrestling mat. You know, when you combine that bit of trivia with his other assertion, he's spent 20 years studying constitutional law, it casts doubt on both. It does cast doubt on both. So, yeah.
With the cops, if they go to arrest you, you can move around. You can not willingly just be arrested. They're still going to charge you with resisting no matter what. If you put your hands by your side, we know that from the Mississippi band direct.
Resisting can come in a variety of flavors. Going limp, it can be resisting arrest. Pulling away, if the officers try to grab your wrist, can be resisting arrest. Federal courts have defined it pretty broadly. I mean, just about anything can be resisting arrest. I think Chili is taking too much out of the facts of the Neves case. I think he's taken them a little too seriously. It's not just the scuffle that's the issue. It's a law was broken. The officers had probable cause to believe a law was broken. And so they made the arrest based on that law being broken. The specific law doesn't really matter. You should be able to extrapolate this out beyond resisting arrest to things like that's why the Neves court made the allegation about jaywalking. Obviously, jaywalking and resisting arrest are two entirely different things, but they're both crimes. That's their commonality. And the reason why they were able to do that is because they extrapolated out from the specific facts of the Neves case to generalized facts. So,
Actor who put his hands down, they tase him and arrest him. But the point is, for activists, you cannot fight them. You can't get into a scuffle with them because if you do, the judge is going to say, "Oh no, you should have just taken the ride and then fought it in court." There's a famous saying that lawyers say.
Yeah, you should. If the cops are going to arrest you, just let them arrest you, and let your lawyer fight it out.
You can beat the rap, but not the ride. That means you.
I don't know if that's really a lawyer saying. I learned that from non-lawyers, but okay.
Have to go through the torture cuffs. You have to go through the strip searching. You have to go through the turnaround, squat and cough. You have to go through all those things to be able to fight for your rights properly.
Oh, retaliation because I challenged the police. And the court said, no, there's probable cause.
Because
you scuffled with the officer.
You can't fight the cops.
It's assault, whatever you want to call it. This is actually an easy case. Now we come to the heart of this case.
If he was at his house and he was wrongfully arrested, then he could scuffle with the police. But I don't recommend anybody.
An easy case. Now we come to the heart of this case.
If he was at his house and he was wrongfully arrested, then he could scuffle with the police. But I don't recommend anybody does that.
I'm going to go with there are some states, not all states, there are some states that allow you to resist an unlawful arrest. There are some that allow that. But that is not a common thing. And so, number one, check with a local attorney before you even think about that. But number two, it's hard to determine whether or not your arrest is lawful because you don't know what the cops know or what the cops think they know. You don't know what information the cops have, right, wrong, or otherwise, that may or may not give them probable cause. So you're taking a huge chance on just being wrong about the law, even if you're technically allowed to resist an unlawful arrest. Oh, I'm gonna have to go soon. I'm gonna have to go here in a minute. But there's also just the reality that you could get fucking shot if you resist arrest, or beaten, or maced, or tased, or whatever. I mean, people die resisting arrest. Cops come equipped. So I'm gonna have to go, folks. It's been real. It's been fun. I wish I could say it's been real fun. Chili's a fucking idiot. Thank you for watching, and have a great day.